Dear students, I welcome you on behalf of Thakur Vidya Mandir High School and Junior College for the remote teaching learning process, where our motto is let learning be a joy and teaching a pleasure. Let us move towards part 1 of chapter number 4, that is issue of debentures, wherein today we are going to understand provisions for issue of debentures as given in Companies Act 2013 as well as Companies Rules 2014, which is related to share capital and debentures. As discussed earlier, debentures represent borrowed capital, that is debt capital of company. It is one of the basic source of raising loan capital to meet medium-term and long-term financial needs of a company. However, a company in order to issue debentures is required to fulfill certain provisions, that is rules and regulations. This includes provisions as laid down in Companies Act 2013, provisions as per Companies Share Capital and Debentures Rules 2014, and also requirements of SEBI. So, let us understand each of them in detail. Let us move towards question number 1, that is, briefly explain the provisions of Companies Act 2013 for issue of debentures. Before understanding the answer of this question, let us have a brief view as to what is the Companies Act. The Companies Act 2013 is an act of the Parliament of India on Indian company law which regulates incorporation of a company, responsibilities of a company, directors, dissolution of a company, etc. Now, this Companies Act 2013 has laid down certain provisions relating to issue of debentures. The first one is no voting rights. The Companies Act 2013 specifies that a company cannot issue debentures which carry voting rights. Debenture holders provide loan capital to the company and as such they are the creditors of the company. Thus, they do not have voting rights like owners, that is equity shareholders of the company. So, it is only the owners, that is equity shareholders, who enjoy voting rights in the company. And as debenture holders represent the creditors of the company, definitely they would not be given any voting rights. Further, they can definitely vote on those matters which affects their interest, that is on those topics which are related to the amount which they have invested in debentures. Let us now move towards the second provision which speaks about the types of debentures that a company can issue. Companies Act allows issue of secured debentures as well as unsecured debentures. As discussed earlier, secured debentures are those on which company provides security by creating charge on assets, whereas no such security is provided for unsecured debentures. This indicates that secured debentures are safe, whereas unsecured debentures are unsafe. Next, it can also issue fully convertible debentures as well as partly convertible debentures. Fully convertible debentures are those debentures wherein all the debentures held by its holder gets converted into equity shares at the time of maturity of such debentures. Whereas, in case of partly convertible debentures, certain number of debentures only get converted into equity shares while the remaining amount of debentures continue to remain as debentures. Further, it can also issue non-convertible debentures, that is the ones which cannot be converted into equity shares. However, it is compulsory on the part of the company to pass a special resolution at general meeting for issue of convertible debentures. This indicates that the shareholders need to pass a special resolution and thereby give their approval that they are ready to issue convertible debentures. Lastly, the Companies Act also specifies that all debentures issued by company must be redeemable, that is, the amount on such debentures must be returned back to the debenture holder at the time of maturity. Thus, this clearly indicates that a company is restricted or prohibited from issue of irredeemable debentures. The third provision is relating to payment of interest and redemption. Debentures being debt capital has to be redeemed, that is, repaid back at the time of maturity. The company cannot keep the debenture amount with it throughout the lifetime of the company. It has to be repaid after a certain specified period of time as it represents the loan capital of the company. Further, the company also needs to pay interest on such debentures. Lastly, the redemption of debentures and the payment of interest on such debentures must be based on the terms and conditions which were specified at the time of issue. The fourth provision speaks about debenture certificate. Firstly, we need to understand as to what is debenture certificate. Debenture certificate is a document which acts as an evidence that company has taken loan from the person whose name is specified therein. Thus, it is a proof with the debenture holder that they have provided loan to the joint stock company. It is thus compulsory for a company to issue debenture certificate, and that too within a period of 6 months from allotment of debentures. The fifth provision speaks about creation of debenture redemption reserve. A company issuing debentures needs to create a separate account called as Debenture Redemption Reserve Account. This account is created out of profits made by company. It simply means keeping aside some amount of profit and accumulating the same in debenture redemption reserve account so that at the time of maturity company does not face the problem of redemption, that is repayment to the debenture holders. Companies Act further provides that the amount which is accumulated in DRR must be used only for the purpose of redemption of debentures. The amount thus accumulated in DRR cannot be used for any other purpose. The sixth provision is relating to appointment of debenture trustees. Companies Act 2013 further specifies that if a company offers debentures to more than 500 people, then it is compulsory to appoint at least one or even more debenture trustees. These debenture trustees protect the interest of debenture holders. They act as the representatives of debenture holders, and that's the reason they always fight for the rights of debenture holders. Further, the company enters into an agreement with debenture trustees which is called as debenture trust deed. This deed contains the rights of debenture holders, obligations of the company, powers of the trustee, etc. The seventh provision speaks about the approach of debenture trustees to NCLT, that is National Company Law Tribunal. Debenture trustees act as representative of debenture holders, and as such they have to redress, that is, solve the grievances, that is, the complaints of the debenture holders. Suppose if a company defaults, that is, does not repay the principal amount as well as fails to pay interest, then debenture trustees can approach NCLT, that is, National Company Law Tribunal, for compensation. On receiving the complaint and after going through the matter, NCLT may give direction to such a defaulting company to pay the interest or even repay the principal amount. The eighth provision speaks about imposing of restrictions by the NCLT. Debenture trustees act as representative of debenture holders, and sometimes it may so happen that they could find the assets of the company to be insufficient to redeem, that is, repay the principal amount of debentures. In such a case, the Companies Act gives them a right to approach NCLT. The NCLT further, after going through the entire matter, may restrict the company in incurring further liability, that is, it directs the company not to raise any finance by means of borrowed capital. NCLT basically does so in order to protect the interest of debenture holders. Let us now move towards the ninth and the last provisions as laid down in the Companies Act 2013, which is punishment for contravention of provisions of Companies Act. The term contravention means going against the law. If a joint stock company fails to comply, that is, follow the provisions as laid down in Companies Act 2013, then in such a case, the company and its officer will be liable to pay fine, or they have to face imprisonment, or they have to face both the consequences. However, this punishment shall be as prescribed in the Companies Act 2013. Thus, with this, dear students, we have completed all the 9 provisions relating to issue of debentures as given under the Companies Act 2013. Let us further move towards question number 2 of this chapter. It states that explain briefly the provisions as per companies, that is Share Capital and Debentures Rules 2014 for issue of debentures. The first rule specified in Companies Rules 2014 is relating to the tenure of secured debentures. The term tenure here basically means the time period for which the debentures are issued. The Companies Rules 2014 specifies that all secured debentures must be redeemed within a period of 10 years from the date of its issue. Only certain companies which are engaged in either infrastructure projects or companies which are given permission by MCA, that is Ministry of Corporate Affairs, or central government or Reserve Bank of India, can issue debentures for more than 10 years but for not more than 30 years. The second provision laid down in Companies Rule 2014 is to create a charge on assets. While issuing debentures, a company must create charge on assets so as to provide safety to the debenture holders. Further, the value of charge should be sufficient enough to meet the entire value of debenture issued and even the interest to be paid. The third provision is relating to appointment of debenture trustees. Further, it is compulsory on the part of the company to appoint debenture trustees before issuing prospectus. It is also necessary to execute the debenture trust deed before issuing prospectus or within a period of 60 days from allotment of debentures. Lastly, debenture trustees contains terms and conditions which have been agreed upon by the company and the debenture trustees. Not only that, it also includes the role of debenture trustees. Let us now move towards the fourth and the last provision laid down in Companies Rules 2014, that is creation of debenture redemption reserve. Companies Rules 2014 further specifies for creation of debenture reserve redemption reserve account. The companies need to create DRR account out of its profits so that it can make the necessary payment to its debenture holders. Further, it states that the DRR account must contain at least 25% of the value of debentures which are outstanding, that is, which are remaining to be paid, that is, which are unpaid. Lastly, money from DRR must be used only for redemption, that is, repayment of principal amount back to the debenture holders. So with this, we have also completed the provisions as laid down in companies, that is Share Capital and Debenture Rules 2014. So today we understood the rules and regulations, the provisions as per Companies Act 2013 and even Companies Rules 2014 for the issue of debentures. Thank you, dear children, for your patience listening.